Hello, everyone, and welcome to this session of All Legal Connect. You are in a thorough examination and interview with a recent trademark examiner. In case you're not familiar with me, my name is Bree Van Til. I am the Director of Education here at All Legal and also your Master of Ceremonies for All Legal Connect. As a reminder, you can see on our on your screen now our code of conduct. Put simply, don't be a jerk. And if somebody's being a jerk to you at this conference, let us know. You can email us at help@alllegal.com and we will take care of it. All right. If you are watching this session live, you may qualify for CLE credit. We are required to keep detailed attendance records, and those will include both whether or not you are in the session and whether it is the active tab. So make sure to be here, make sure it's the active tab. Not that I think you would be trying to do anything else instead of listening to this. It's going to be amazing. I will announce a code at a random time during the session. Make sure to write that down. We will ask for that in a survey, and you need to have the correct code in order to get CLE credit. So again, you need to be here. You need to be here the whole time. You need to have the window open, and you need to have the code and put the code into the survey. And our CLE provider is only offering credit for the live presentation. So if you're watching this on a recording, that's perfectly fine, but you can't get CLE credit for that. In terms of chat and questions and things like that, feel free to use the chat in whichever platform you're in, whether you're in Big Marker or Umbrella. Feel free to use the chat there. If you have any questions for Dorna and Courtney, make sure to use the tag @presenter, and we'll get those over to them, make sure that they can answer them. All right, so I'm really excited to announce our speakers. Real quick, for starters, Dorna here, who has an exciting announcement that she just won a thing yesterday. She counsels clients from a wide variety of industries on all aspects of trademark law and brand management, from selection and clearance to enforcement and licensing. Dorna helps her clients build their brands and develop enforcement plans tailored to their goals. Prior to joining Frankfurt Kurnit, Dorna was an associate at Wilkie, Farr & Gallagher, where she focused on trademark, copyright, trade secret, and other intellectual property issues related to due diligence assessments in connection with mergers, acquisitions, financings, and investment. And as of yesterday, she told me she is being recognized by Best Lawyers in America in the 2021 edition of Ones to Watch for intellectual property law. So let's all congratulate her on that. That's super exciting. Yay! And then next we have Courtney, who's the founder of CMA Trademarks, a boutique law firm providing high quality, cost effective legal services to clients seeking federal trademark protection. Courtney uses her decade-plus experience as a trademark examining attorney at the USPTO to help clients successfully register their brand names, logos, and slogans. During her time at the USPTO, Courtney wrote statutory refusals and appellate briefs and reviewed over 10,000 trademark applications. She leverages this experience to help her clients register and protect their trademarks. We are so grateful to have her here. She's going to tell you all the things about the USPTO. I won't say she's going to dish out the dirt, but she's going to tell us all sorts of things that we really want to know and that will make it so much easier as trademark practitioners to do our jobs. So thank you so very much. We're super excited for this. And I'm going to go away so that you guys can talk. Thank you so much.
Thank you, Bree.
Thank you, Bree.
I am having trouble seeing our slides. I don't know why that is. There we go. Okay. Before we get started, I just want to flag for everyone, I'm sure our wonderful team at Alt Legal has given you the link to the materials for this presentation. We included a handout, if that's the way you want to do it, that has the slides on each page. It's a PDF plus a section on the page where you can type in your notes related to that slide. So if that sounds like something you want, you can go grab that out of the materials folder that I'm sure the Alt Legal folks are sharing. So let's be honest, we know Courtney is the star of this show. As Bree said, Courtney was a former PTO trademark examiner for 11 years and now owns her own boutique prosecution firm. And I'm going to start with letting her give a little disclaimer, because what kind of attorneys would we be if that's not how we started?
Hello, everyone. It's a pleasure to be here. Thank you very much, Dorna. So my disclaimer, of course, everything I say here today are my own thoughts and do not represent the views of the USPTO or the United States government.
Okay, got that out of the way. So let me give you a little bit of a roadmap of what you can expect from this presentation. We're going to start with a little bit of background from Courtney about who examiners are, who are we dealing with on the other side of this prosecution experience, the background and the training that they have. Then we're going to go into the mindset of the examiner when they first encounter a new application, the questions they ask themselves, and the research they do inside and outside the four corners of the filing. From there, we're going to talk about the actual process by which they decide to issue office actions or pass applications through, and the various systems that are in place at the PTO that impact that process and the speed or lack thereof at which it goes. And then Courtney's also going to give us some real insider tips on how to utilize tests for searching both for word marks and for design marks. I was a bit cocky and thought I knew what I was doing. And then I spoke with Courtney and realized there was a wealth of information I didn't know about when it comes to searching on tests. So hopefully this will be valuable to you. So with that, we'll get started on part one and ask Courtney to tell us a little bit about the educational and training backgrounds of examiners at the PTO.
Thank you. So the USPTO requires examiners to have a law school degree, but you might be interested to find that having results from the bar exam is not necessarily a requirement. Once in a while, the USPTO does hire recent law school grads that are actually waiting for the results. They do have to pass the bar to keep the job, though, so some added pressure there. As far as professional background, there's typically no requirement that examiners have specific trademark experience. So the backgrounds of examiners are extremely diverse. They're coming from law school, they're coming from associates at big firms, or they're associates at big firms, in-house counsel positions, a wide variety of practice areas as well. As far as the training, right when you get to the USPTO as a first-time examiner, you're going into their training program. It's very robust. It's a several-week program. When I was there, it was actually 7 weeks. And you just have new hires that are sitting in a classroom. They're all day, and they're learning everything they need to know about the job. They're learning trademark law. They're learning good examination habits. They're gaining proficiency with the computer systems that the PTO uses. They're learning how to search marks. They're understanding the substantive refusals and all the procedural requirements. After the examiners finish the training program, they aren't just let loose. They start examining under a very careful eye of a mentor and also their supervisors. So in the beginning, all their work needs to be approved by the mentor the first few months. If they're doing well, then they can gain what's called partial signatory authority. Several months after that, if they're doing well again, then they could achieve full signatory authority. But it's a very gradual process over the first year to year and a half, actually, before new examiners can completely work on their own.
So it's kind of, they begin with a trademark boot camp, it sounds like, and then continue on to an apprenticeship almost.
Exactly.
Glad to know it's such a robust training program. Okay, with that background in place, our newly trained examiner or our seasoned examiner has received one of our applications. How did they receive it to begin with? What's the process for assigning applications to examiners?
Right, so the process is completely random how applications are assigned to examiners, with two small exceptions. The first being special marks are going to specific examiners, and the second being applications with the same ownership waiting to be assigned will typically go to the same examiner. So for example—
Can I ask you about that second one first?
Oh, sure.
Okay, because this is something I think a lot of trademark owners and filers wonder about and even try to game. I've heard attorneys say, well, I'm going to try to take these similar applications that maybe I'm expecting might receive some of the same issues, either because the ID is the same or the marks are very similar. And in the hopes of trying to get one of them through, I'm going to stagger how I file them. And what you're telling us now, I really want to flag this for everybody, is if the owner of the filings is the same, staggering them won't have an impact on who reviews them. Is that right?
That is correct. As long as that owner matches up, because the system's flagging it. So if there was if you put, if one said Inc. at the end and didn't for the corporation, then that might throw a little wrench into it. But as long as those ownerships match up, if you have marks that are waiting to be examined, they will typically get assigned to the same examiner and examined at the same time. So you might have sent one 3 months ago to the USPTO and that one's about to get reviewed, but you also might have just submitted one 3 weeks ago and you might be shocked it didn't have to wait that 3 months of dependency that's normally required.
So can't game the system that way, folks.
No.
And then you mentioned special marks. Can you tell us what you mean by that?
Sure, there's certain examiners that are assigned to various special marks for consistency purposes. Now, you might think of normal ones like sound and motion, color marks, but there's also other categories of special marks that the USPTO designates. Some of these include political marks, geographic certification marks for things like cheese and tequila. Olympic marks are made special. They have specific examiners. And usually any kind of big news event in the United States usually gives rise to a need for a special mark. For example, 9/11 was a big category, or more recently, Kobe Bryant became a special mark. The special mark that probably gets the most attention these days are the cannabis marks. There's actually a need for several examiners that specialize in examining cannabis marks, and they're practically on a full-time basis solely examining those cannabis marks.
So we want to flag for you, if you listened to Brandon Branch's wonderful presentation yesterday, this is one more point to think about when you're working in the cannabis field for trademark prosecution, that the PTO has a specific office of trademark examiners dedicated just to marks relating to cannabis. Yeah. So that tells us about how the marks are assigned. Can you tell us a little bit about what an examiner is thinking and doing when they are finally reviewing an application for the first time?
Right. So when an examiner first pulls a new application, they're looking at the wording in the mark. They're wondering, what does it mean? Is it foreign wording? Is it completely made up? Is it surname in there? Is there a possible name of a living individual? Any acronyms the examiner needs to figure out what they mean? So they're checking dictionaries, they're checking acronym websites, they're checking translation dictionaries, Google searches, possibly Lexis. And then they're just kind of going down their checklist and they're evaluating the words for any kind of descriptiveness, geographic descriptiveness, deceptiveness. They're really searching the internet to see how the words or phrases are often used in relation to the goods or services that are applied for. Then, a big part of the examiner's job are what are the goods and services? They need to correct identifications of goods and services and suggest better language to the applicant. To be able to do this, they need to really spend time on the applicant's website and search the internet to understand the particular goods or services listed in the application. The examiner also has to make sure all the procedural requirements are met, and they're checking other substantive refusals like failure of function and specimen refusals if applicable. So as you can imagine, examiners are spending a lot of time on specimens, especially these days. Let's see, last but not least, a big portion of the time spent on an application is conducting a search for conflicting marks. Examiners conduct many searches per day. They're analyzing the search results, and if similar marks are found, they need to research if the goods and services can emanate from the same source and obtain that evidence for relatedness.
On that issue of searching for conflicting marks and the evidence that the examiners provide, I've always wondered how they go about selecting that evidence. For example, if the refusal is based in part on a application or registration where the goods aren't identical, but the examiner is taking the position that they're related. They usually back that up with evidence that's not just other filings that contain both categories of products, but also internet evidence. How do they go about selecting that internet evidence?
Yeah, well, I mean, as you can imagine, it's just getting really good and proficient at, Google searches or any other search engine. Examiners they have a wide range of knowledge from looking at all these different applications day in and day out. So they're really honing in on that website evidence. Third-party registrations, as you mentioned, are important, but you can't rely just on third-party registration. So they need to have that website evidence in there. And they can also access Lexis if needed. You might see that definitely for surnames, but it's also for relatedness. They do have available, the trademark office has a law library, so they're especially helpful when it comes to varietal searches. But basically they are very proficient internet searchers. So, the interesting thing is, as you can imagine, when you're an examiner, you tend to see the same refusals over and over again. So a lot of examiners kind of have their go-to evidence. I know I personally always had like clothing stores versus clothing accessories, restaurant services versus a particular food item, relatedness of various alcoholic beverages, things like that. You tend to see it over and over again, so you're gonna have it ready to go to make your life easier.
That makes a great deal of sense. Kind of piggybacking off of that, same question, but about the TTAB decisions examiners cite in their office actions. Do they have a bank? Are they constantly staying up to date on new decisions? Do they read the TTAB blog like us? How do they go about doing this?
Yeah, of course, the TTAB blog it's very actually strongly encouraged at the PTO, but the PTO is keeping the TMEP and boilerplate form paragraph language that the examiners use. They're keeping it current. And the office has regular emails that summarize all the TTAB decisions, so examiners very much can stay current on any decisions that have been made lately. And managers are regularly speaking about the important decisions at staff meetings and the impact they might have on examination.
That is fascinating. So that tells us a little bit about how examiners are thinking when they're reviewing applications. A couple questions now about how examiners, should we say, feel about the attorneys or lack thereof who might be assisting in the application process. I have heard in trademark attorney circles comments that pro se applicants just get extra special treatment and things like that. And I thought this might be a good opportunity to address those suspicions. So can you tell us a little bit about what examiners think when they see a pro se application and what that's like, how it feels for them to work with attorneys who are not trademark specialists versus how it is for them to work with attorneys of record who are trademark specialists?
Sure. So, contrary to your belief, all applications are evaluated exactly the same. The difference for examiners is that pro se applicants actually require a lot more patience. They result in long phone calls, lots of errors on the online forms. Many times pro se applicants call actually right when they get the office action before even opening it up. So many times examiners have to explain the refusal that they just issued 5 minutes ago over the phone. So that's, that results in a lot of headaches, but you still have to offer good customer service.
Of course.
Pro ses oftentimes have problems with the online forms, so they're always calling about that, and examiners have to try to help them or refer them to, the technical departments of the PTO. They're always submitting unnecessary things, attaching specimens incorrectly, forget declarations. You can imagine how much time pro ses are for the examiners. So actually, trademark attorneys definitely make it easier. They're a breath of fresh air when it comes to all the procedural stuff and the forms. So. Good. Yeah, so that's actually, examiners like that, they like their job being made easy. They don't want to have to correct ownership and little things like that for an application, addresses and things like that. As far as it goes, attorneys that maybe just dabble in trademarks, sometimes, it's very easy, I should say, for an examiner to tell when that's the case, because they might not have great knowledge of the substantive refusals they're calling about. So examiners have to be a little bit more patient with them as well.
Great validation of why we all do what we do and why we love it so much. So you hear that, folks? Trademark attorneys matter. Okay, so now I want to talk to you a little bit about the systems at the PTO. If you're only half listening, this is the part where I'm going to tell you to pay attention, because this is, to me, where the meat and potatoes of this presentation really are. So Courtney is going to tell us how there are 3 different systems in place that dictate the review of applications, the speed at which they're reviewed, and the quality control. Those are the production system, the quality review system, and the internal deadlines that examiners face. And then we're also going to talk a little bit about the roles played by examiners' supervisors. So let's move into that. Courtney, tell us a bit about the production system. What is it? How does it work?
Right. So the production system is how the PTO actually measures how much work the examiners are doing in terms of application review. Examiners are required to produce a certain amount of points by the end of each quarter. They're technically called balanced disposals, but today we're going to just call them points. Each class in each application is worth 2 points. So how it works is the first action taken on an application, whether it be an office action or examiner's amendment, or suspension letter, all that is worth 1 point. That's the first point. And then an action leading to the disposition of an application, whether it be a proof of publication or an abandonment, that's also worth 1 point. So you get 1 point in the beginning and you're getting 1 point at the end. So final actions in the middle, they're actually worth no points. So all you attorneys out there that think examiners love to issue these final refusals, think again. They're very time consuming and they're worth no points to the examiners.
So this is a big takeaway, I think, what Courtney just said, because I think we are tempted to believe that maybe examiners just hate us a little bit and are trying to make our jobs harder. And that is not the case. They get the same number of points, right?
Correct.
Once an application gets to publication, regardless of whether or not they issued office actions.
Right. Whereas alternatively, higher quality applications with little to no issues, they're easier to move along and you get the points from quicker. So if there's no issues, you're getting your first action point and you're getting the point at the end when you're approving it for pub. So there you go. It's 2 points just like that. So examiners love those.
So examiners would love for excellent quality trademark attorneys to do all of the filings they review, because that means points without issue and without time consumption.
Exactly.
But we're going to talk a bit. So that's a kind of a carrot and incentive. When we get to quality control, that'll get us to why they don't just approve everything right off the bat. But that leads me to want to ask about foreign filings. I'm sure many of our listeners, either through working with foreign applicants or through encountering foreign filings as a result of searching, have noticed that certain filings, whether they're 44DE or Madrid Protocol, have incredibly long, incredibly intricate lists of classes and lists of goods and services in those classes. Are the points the same for an application like that? I feel like I've read stories of applications being as long as novels.
Yeah, they are the same. So foreign filings, it can get tricky for an examiner there. They can waste a lot of their day on long identifications. So 44Es, I would say, especially D&Es, are especially time consuming because I don't remember the same class. Like for Madrid, you're dealing with longer, you have multiple classes. So it's more worth it to the attorney if you're thinking of the point system I just explained. Whereas the 44s, they tend to only be like 1 to 2 classes and they have the foreign certificates that need to be reviewed. So it can get pretty daunting. Madrid's, they're a little different. Some examiners, especially the more seasoned ones that are really good at quickly fixing the identifications, they actually like Madrid's because they frequently have several classes, so you get more points. And they consist of usually unique wording, not all the time, but a lot of the times. So you're not really worried about a lot of Section 2D refusals when it comes to Madrid's. I can't say the same for 44Es. This is specific to Madrid's. So, and there's no specimens to review for Madrid's as well, and there's no foreign certificates to review. So, it's kind of a mixed bag with the foreign filings. They definitely get interesting now.
You mentioned earlier that there are specific law offices for special marks. Are foreign filings, whether 44 or Madrid, do they qualify as special marks, or do all examiners deal with those?
Good question. They all deal with those. So every examiner is having to examine some 44s and some Madrids during their week. So they have to get used to them. Whereas, no, and just, I'm sorry, small correction. It's not actually for special marks. Dorna, you said an entire law office. It's not. It's specific examiners handle special marks, not an entire law office.
Thank you for that clarification.
Mm-hmm.
Okay, so that's the production system. That's the examiner's carrot to be efficient and be kind-hearted to us poor prosecuting souls. Tell us about the quality review system. What's to stop an examiner from simply approving every application and racking up points as quickly as possible?
Yes, that would be so nice, but no, you cannot do that. You have to make sure you're doing your job well. So the quality system, the quality review system, it's used to ensure quality control. And, office action searches, trademarks approved for publication, all of that they're all being regularly reviewed by 3 different methods, really. You always have your manager reviewing and rating examiners' works. And you also have a separate quality department at the PTO that's pulling files and rating examiners' work as well. And then the marks that have been approved for publication, they're getting reviewed as well. So examiners really must balance how fast they're working, how fast they're producing, with the job, doing the job well, because the quality is getting reviewed all the time.
And what are the consequences of having a history, let's say, of maybe not issuing some office actions that needed to get issued, or being an examiner whose applications frequently get pulled from publication after that last stage review?
Yeah, if you rack up a lot of those, you're going to get errors, and it all goes into your quality rating by the end of the year. It affects bonuses. There's some bonus potential if you have good quality. So it's not a good situation. You definitely do not want your quality to go down the hole, for sure.
So there are financial consequences even for our examiners. I know We're getting to the end of the year. People might be thinking about bonus season. So are the examiners, it turns out.
Right. And Dorna, bigger picture, both these systems, the production and quality review, because they're so transparent and quantifiable, it actually it's the reason why the PTO has one of the biggest and most successful telework programs in the federal government, because you're literally seeing that examiners are performing the same at home as when they're in the office. So, I mean, attorneys have probably heard of how most examiners they're calling are at home. That's true. The teleworker program is absolutely huge at the PTO, and this is why.
Thank you. Thank you for sharing that. I think also something people might be paying a little more attention to and thinking about in our new age of working from home these days.
Right.
So you mentioned supervising attorneys and managers. Could you go into that a little bit more? Tell us about their roles, and also maybe tell us how one becomes a supervisor or managing attorney at the PTO?
Sure. Well, as far as how they become, just like any job, there's job opportunities at the PTO and they're looking to fill. So it's just submitting an application. Usually it takes being, mentoring examiners to lead to that, to have good qualifications, but everyone can kind of put their name in the hat, so to speak, and work to a supervisory role at the PTO. As far as what they do, I think we touched on before, they're serving as mentors for new examiners a lot of the times. They're answering any hard questions examiners are stuck on. They're reviewing the marks approved for publication. That's one thing we mentioned earlier. They're holding staff meetings, they're handling timesheets, they're going to higher level meetings. These are just some of the responsibilities I knew of. I'm sure there's probably more that I didn't know, because I never held a supervisory position at the PTO.
And regarding supervisory attorneys, from the outside attorney or applicant's perspective, are the supervisors inaccessible? Are they behind some internal wall at the PTO where we can't reach them? Or do they ever communicate with applicants or applicants' attorneys?
Yeah, the supervisors talk directly to applicants. I would say the majority of the time it's cases where the examiner is out of the office and the matter is urgent. So the applicant or the attorney for the applicant tries to get a hold of the supervisor. You can imagine people kind of run up and right until their deadlines. And if it's a day off for the examiner, they're trying to get a hold of somebody. So that's a lot of the times when supervisors are dealing directly with the applicant. I guess a more rare instance would be if an applicant's being really rude or difficult with an examiner, the supervisor is going to handle that. Applicants' counsel can speak to the supervisor if they feel it's needed. I'm sure the examiner is going to try to rectify the concerns, but ultimately they're not going to have a problem if escalating it is requested. But I would say it's rare that trademark attorneys or any attorney for that matter asks for this, but it does happen.
Okay, so folks, we're not giving you a license to Karen your way to the supervisor whenever you want. But it sounds like from Courtney, in those instances where there's a disconnect, on those rare occasions where you may think it's necessary as a zealous advocate for your client to speak to a supervisor, it does exist as an opportunity. But as Courtney said, rare instances. So that tells us about how the quality control system works. There's also this third element of internal deadlines. And this plays a role a bit in terms of how examiners decide to treat an examiner's amendment versus an office action versus just a phone call or an email to the attorney of record. So could you tell us a little bit about how that works and how it impacts examiners' decisions on how to proceed?
Right. So examiners have a 7-day deadline to act on first actions. So when they pull a new application, they're going to have 7 days to take action. And they have a 21-day deadline for final actions or other office actions that stem from the applicant's response. So it's in the examiner's best interest to rectify issues over the phone or email when possible, because they're also rated for an examiner's amendment usage. The PTO strongly encourages examiners to be using the phone or email to fix issues so that the application can move faster along. So you might have seen emails from examiners giving you a deadline to respond, or then they say they'll have to issue an office action if you don't. And that's why, because of their deadline. So they're giving you a deadline. So if they run out of time, you might see an office action on something that could be rectified over the phone or email. For example, a disclaimer. You might be like, why did they issue that office action for a disclaimer? They could have just called me. And, they must have just had a really full docket and they're just getting out. But is it in their best interest? No. So, it's just that they ran out of time in their deadline and they couldn't get a hold of you.
And we touched on this earlier, but I'd love to go into a little bit more depth. As part of the quality review system, and I'm sure this has happened to many of us, we've seen applications that we've reported, oh, this got approved for publication, congratulations, we're good to go. We see them get withdrawn. And can you go into a little bit more depth about that, perhaps the refusals with which that's most common, and kind of when we should expect something, or could we expect something like that to happen?
Right. So the supervisor attorneys, they are reviewing all the marks published for opposition, and sometimes they're finding errors. I would say the most common errors that they're finding at this stage are with the identification of goods or services, or descriptiveness issues that result in a 2E1 or even just a disclaimer. They can also find deceptive issues or other substantive problems, but I would say the biggest ones are they're finding the disclaimers and problems with the identifications. So when an error is found, the application is withdrawn from publication and it gets kicked back to the examiner, the same examiner, to correct the error. I know attorneys hate when this happens, but examiners probably hate it even more because they are, getting an error and it does affect their quality rating. So so that's some of the reasons why you have the withdrawal from publication.
So that covers the three elements. I do want to go back and touch on one more thing. This was on me, I forgot to ask. We talked about when applications are being assigned to examiners, how there's an intent behind getting applications with the same owner and that otherwise have these common characteristics to the same examiner for the sake of consistency. I think some of us have occasionally seen when that doesn't happen, when despite the applications belonging to the same owner, they get split up and then get treated differently. What do you recommend, or is there a means by which counsel can try to reach out to the PTO and say, actually, these are all related, they're all should be fielding the same issues? Can we get them to the same examiner, or can the examiners talk to each other?
Yeah, I mean, that's exactly what the USPTO is trying to do. If that happens, if they are split between examiners, they're they're required at the PTO for the examiners to talk to each other. Sometimes it makes more sense for one examiner, if they only got 2 of them and the other examiner got 5 of the co-pending applications, that maybe the one with just 2 will give it to the one with 5. So they are, strongly encouraged, if not required, to do this. If they decide they're going to work on the ones that they pulled, then they should be working together to make sure that they're reviewing the identification the same exact way, making the same suggestions. We're not trying to make it harder, or I should say I'm not there anymore, but they're not trying to make it harder for the same owners to have to deal with these issues. So it is important at the PTO that the consistency there, and that's what they're doing as well. So yeah, I mean, it could be requested, but they're going to be doing that behind the scenes anyway. If for whatever reason it's not being done, then it can be brought up for sure.
And how would you recommend folks bring that up? An email to one of the examiners,
Exactly.
a phone call? Okay,
exactly.
Great.
Yep.
And then going to the points versus the quality control again, are there any minimums when it comes to office actions or amendments or anything like that examiners also have to abide by?
Yeah, there is a minimum first action requirement. I would say that the normal examiner does not really have to worry about it too much, because if you're examining applications in the correct way, that first action number is just going to come, as long as you're not approving everything for publication and you're doing your job correctly. But it is there. I never really had to pay too much attention to it, because as long as you're doing the job right, you're going to have to issue a certain amount of first actions.
Yeah, so the natural flow of the applications you're reviewing are gonna lead you there regardless.
Exactly.
That makes a lot of sense. And then I'd love to hear from the examiner's perspective. When you're examining an application, when did you find it useful to escalate something yourself, to go up to your supervisor for help or for advice on what you thought was a particularly thorny issue?
Those situations, they're really just maybe when you're issuing refusals that you might not see every day. You might need to talk to your supervisor then. Maybe it's a hard configuration mark, and they don't come around that often. So when they do, examiners kind of have to relearn some things to make sure they're doing it the right way. So they might check with supervisors in those instances. Really, sometimes there's issues of clients, that have identifications of things that are very novel, like these goods. They're not in the identification, manual, and you look on their website and they're doing something completely different you've never heard of. So you're just wondering what class it would be in. So those are instances that examiners have to go to their supervisors when they're just trying to get to the bottom of where this belongs and what to even suggest. So, and sometimes the supervisors even have to talk to different departments, like the ID class department, because, they're the experts there. So sometimes they need to escalate too. So it can be teamwork when there's things that come up that aren't the norm.
So are we right to imagine that maybe the same way in our offices, way back when we were in offices, we might drop by a colleague's office to discuss an idea or run something by them, that examiners are doing that with each other as well as they look through applications?
Absolutely, right. When I was actually in the physical office, it was, a very much a work environment where you're always popping by to get opinions on Section 2D refusals and things like that. You can, the supervisor would keep their door open sometimes if they could allow for pop-ins, shut the door if they weren't. So it's very much an environment where everyone's trying to help each other. Now, when you go to telework, you're usually just sending chats. A lot oftentimes to get advice that way, but it still is very much an environment where everyone's trying to, help each other and for the common good here.
The common trademark good?
Common trademark good.
And keeping in mind what we know about the point system and the quality review system and how this ties into even bonuses and everything, how many applications is any given examiner juggling at one time?
It kind of depends on the examiner. I would say the office suggests that you're not pulling massive amounts of files at one time, but some examiners work better that way under pressure. So, I mean, I can think of a few old colleagues that, maybe they just pull 20 at a time because that gave them the pressure to see those in dockets. So it depends how you work, but it could be anywhere from, examiner could just work better pulling one at a time, or you could have a docket of, 20 to 30 at a time. But, then you always have the response docket that's full of glorious things like, final refusals that need to be issued and things like that. So you have to balance your docket and, make sure you're working efficiently.
Of course. And then as having been on both sides now of this, of the examining prosecuting divide, is there any particular PTO resource that you wish outside counsel and applicants knew about more, or in-house counsel? And what I mean by that is attorneys who aren't on the PTO end, that you wish they knew about more, that they referenced more, that you think if we spent some more time with this resource, we'd make your and our lives a little bit easier?
I don't know. Is it just generally the TMEP? It's just the examiners just know that they're looking at that every day. I mean, it is just completely, it's minimized on their screen, the TMEP, like it's just their Bible. So, the more you can familiarize yourself with it, the better off you'll be.
That's the Trademark Manual of Examining Procedure. I think we also included some examples of the types of practice updates that the PTO issues about new trademark matters or new decisions. Would you say those are good things for attorneys to keep track of as well?
Absolutely. The exam guides that are issued by the PTO, very informative, especially with any changes that have been made to the office as of late. So very important to keep up to date on that.
Great. So with that, we'll go to the last phase of the inside information that Courtney is going to provide for us. And that's some advice on how to search on tests. So we're going to do an example of both a word mark and a design mark. And we're going to try to go into some depth here because I think these, personally, when Courtney shared this stuff with me, I thought it was incredibly valuable and can really increase the value add that attorneys can provide to their clients. So she's going to talk to us a little bit about field codes and design codes, but also specifically about how to structure searches so that you can pull the kinds of potential conflicts that might not immediately jump to mind. So I'm going to let you take it from here, Courtney.
Okay, so gave an example word mark here. I came up with this. Sorry, it's pretty lame, but yesterday's secrets, and it's going to be class 41, entertainment services in the nature of live visual and audio performances, namely musical, variety, news, and comedy shows. So just to give you a little glimpse of how an examiner is going to approach a search. When you're looking at it, well, first of all, searching is an art form, and it could be a several-day course all in its own here, but hopefully you can find just a little bit here useful. So looking at this specific mark is you want to break the mark down into chunks while thinking about what could possibly be confusingly similar. In this example, you'd want to break apart the word yesterday because a mark like yesteryear secrets would be a problem, and just as days secrets would be a problem as well. So you need to make sure you're breaking apart words that make sense to pick up any kind of likelihood of confusion refusals here. So if you look on the end, I used asterisks, and if you're not familiar, they're really, really important. You want to use asterisks on each side of the term to pick up any marks that might have these terms combined with other letters or words directly before or after them. As many trademarks, they smush together the terms and they don't use the spaces. So this really helps get all the marks you need. The asterisks will also pick up marks with different prefixes and suffixes and pluralization. So that's important. Different endings, different beginnings. You need that root word in there. That's really important. So then it's all about using the brackets for vowel replacements and pattern matching. This is where you really need to think of license plates and how creative people can get with spellings. While there's, some hard and fast rules examiners must follow when searching, some of it is really just fact specific, and you need to ensure that you're finding all the ways that marks could be confusingly similar here. So getting into the nitty gritty. When we're looking at yester, of course, starting with the Y, but then you need to look at the vowel there, E, and I did a V:2. So that's going to pick up any instances where there's one or two vowels. So it could pick up two E's, it could pick up an E and an A. You get the point. So, that way, if and a mark has any kind of combination of vowels in there, it's going to get picked up. Moving on to the S, whenever you search an S, you should typically be searching a Z2. They're phonetic equivalents, so it's going to pick up marks that use creative misspellings.
And so, I'm sorry, those quotes that surround the S and Z are how you're telling the search engine in its own language that you're putting two phonetic equivalent letters in the same space.
Correct. So it's going to pick up an S or a Z when you use those quotes. What you could also do too is, in some other places it might make more sense, but you can always put after those quotes a 1:2. And that is important if you want to pick up two S's or a Z and an S. So you can use numbers after those quotes too, with that colon, how it's used for the vowel before that. So, you got to think that way too, because sometimes there's duplicate letters. For example, moving on, the T in this case, I did a TD in the quotes because yesterday, you can see how someone could slur that and use a D instead. But lots of times when a T is in a mark, it could also be a double T. So, when I search marks, I'm frequently doing a T in quotes with the numbers 1:2. And that way it's going to pick up words that double the T. But in this case, I decided that wasn't important here. Today, this instance, I wanted the T and the D sound, because yester could be yester with the D. So the vowel, I wanted to show you the difference here. The V:2, this is picking up, this is different from the beginning of the term here, because this one's going to pick up instances where there's no vowel. That's what the 0 means. So that's the difference. And, that's really thinking of license plates. Sometimes you're just excluding all the vowels. Now you could get crazy and, trying to do this, and you could end up replacing every vowel with no instances and just have all consonants. But, you kind of have to use some logic here too. So I just wanted to show you how you could also take the vowel out entirely and put the R on the end for yester. So
license plates are a really good example of that. It also makes me think of the trend with tech and app names these days of dropping vowels.
Absolutely. You have to think of the drop vowels for sure, but, also using common sense, because it could all make you crazy, all the vowel replacements here. So moving on to the word day. So here, because it had a pluralization, first of all, you want to drop that with the truncation of the asterisk, but you also have to think of the pluralization. So I did two instances because you want to do day by itself, but days, it could also, if you look at my second line there, it can be also spelled D-A-S-E or D-A-Z-E, like dazed and confused, so you want to be able to pick that up, but at first you're just wanting to search the word day without the pluralization. So I did D-A, and then in the brackets, I did the quotes Y-E, in case day is spelled a creative way, D-A-E, or, lots of times when you're searching E or Y or I, you want to combine all three. So I didn't put the I in this instance. I could have D-A-I. I guess that could have been day as well, but I just stuck to the Y and the E. But it is important to remember that lots of times I are with those sounds too, the E-Y-I phonetic equivalent. And then moving
Tell us what the BI and the TI in the brackets mean for anyone who might not recognize that.
Right. In case you're not familiar, the BI means you're searching the basic index, and the TI means you're searching the translation index. So that's going to pick up any words that are in translation statements which are important. So if you're just doing BI, you might want to consider adding TI to your searches in the brackets. If you want to just search marks that are live, you could say not dead and add that. The PTO website on test, it has all these endings in the brackets. It has all the indexes, so you can check it out and start to get play around with it.
And in case you don't know where that is, folks, when you go to tests, if you click on the free form version rather than the basic rather than the basic search version, on the lower half of the page on the free form version, you're going to see all the different categories that you can put in brackets in which to search. And so that's when she sees you see that, when she says you see that on tests, that is what she means.
Right,
I'm sorry I cut you off. You were going to tell us how you are now going to search for secrets.
Yeah, thank you for that, Dorna. Yeah, so with secrets, again, we have the SZ sound. And then here I put the E in because I feel like you need that E in this situation. And then I added the vowel, the brackets with the vowel after it, because I'm thinking of spellings like CEE or CEA. Now maybe 3 vowels is a little overkill because you have the E that I already have, and then you have up to 2 more, so that's a total of 3. Might be a little overkill, but maybe someone decides to spell secrets with 3 E's. Maybe they're really excited about the beginning of that word. So, you know, you can pick that up. And then with the C there, I did a CKQ in quotes. And this is another example where you can put the 1:2 because a lot of times CK are used in the same word, you know, in conjunction right after one another. But, you know, this one I decided to just do, it's just going to pick up if there's a C or a K. Could you do SECK? All right, sure, you could do that too. So if you want to throw it in, 1:2 would pick up if there was both a C and a K, not just one or the other. And then we have the R and then another vowel within the brackets to pick up if there's either no vowel or up to 2 vowels. And then we end with the T. So the first thing you want to do is search the terms together. As you probably know, it's important to perform a knockout search. You can right away see if you have any hits. You know, but then you're going to want to search the terms separately. It might not be important to search day specifically separately in this example, but you're definitely searching if there's any combinations of yester and secret or day and secret. You know, secret is, you know, probably the most important part of this mark. So you're going to play around with any kind of different combinations. When you're searching the term separately, if it yields too many results, you can always try searching within coordinated class. So that's going to be the CC in the brackets. That's what coordinated class means. And that's going to pick up related classes, not just the one that you're interested in. And you'll see that I did class 9 here. You might be wondering why. Or maybe you're not, and you're good at this. So I'm
wondering why, so please tell me.
Why. It is not a typo. I searched class 9 because it picks up goods that are related to applicant services like pre-recorded DVDs, as well as the class 41 entertainment services. You know, you have to keep thinking about what goods are related to what services. It's really important when you have a trademark for services, you need to think of those goods that could be confusingly similar and related. So that's why I did class 9. Did that help, Dorna?
It did. Thank you.
Okay. So I think that wraps up the word mark example.
Well, I did want to ask you a question, but I want to give Bree the opportunity to share the CLE code first.
Oh, yes.
Yes.
Sorry, Bree.
I don't want to interrupt. I could listen to this for hours more. Okay, so let me give you the CLE code really quickly. It is LHB5U. That is lifetime happiness begins with 5 universities. Whatever, guys. LHB5U. Carry on.
Thank you, Bree. Lifetime happiness begins with efficient test searching. Before we go to the design mark, Courtney, what I wanted to ask you was, on the searching end, when you're trying to clear a mark, we often wonder how much we need to be concerned with marks that it's not a question of the words or the designs being similar, it's a question of commercial impression and meaning. In your yesterday's secret example, do you think most examiners would search also for something like yesterday's confidences and cite something like that? Or do you think that would be a less common search?
No, I think that would be less common. I don't think examiners would be searching, you know, a lot of synonyms or, you know, words that you might think are similar. You know, they really have to have a commercial impression. I can just, you know, remember the example that when I used to search, the only times I would do that are instances like home or house or life or lived. These are ones when I tried a different word, but it wouldn't be as different as confidences for secrets. Does that make sense?
Okay. Yeah, it does. That gives us that certainly makes that area a little less gray for me. So hopefully everyone found that useful. I certainly did. And I'm hoping now Courtney can give us some insight on some tips and tricks for searching design marks that are just as useful.
Sure. So I have this example design mark. I got it from the TMEP, so I did not have to create something. So you'll see a house on top of an elephant. So here you only have two designs you need to worry about. You have the elephant, which if you look in the USPTO Design Code Search Manual, that is where you're going to need to find the code so you can search these sufficiently. So for elephants, when you type it in, you get a couple of codes. You can get elephants in general are 030301, but then you have heads of elephants that are different. They're 030316, and then you have stylized elephants 030324, and then costumed animals that can include elephants, and that's 030326. So to make sure I get all of them, I'm going to use the truncation symbol of the $sign. So you notice that they all start with 0303. So I'm going to use that beginning. But so to make it easier, just to make my life easier and to pick up all the ones that I just told you, all the different variations of elephants, I'm going to use that $sign. And that's going to pick up all the different variations for elephants in one. And then I'm going to do the same thing for houses. Farmhouses are 070102. Row houses are the ending 03. They're all starting with a 0701 if you look in the Design Code Search Manual. But you have detached houses, the ending 04. Apartment houses 05. You get the picture. I want to pick up all of them. So I use that $sign again, so that way it makes my life easier and I can do a complete search. So I'm going to search for them together for that knockout search, and then I'm going to search for them separately. You're not, as I think about it, you're probably not going to cite a design of a house with no elephant, but maybe it's a really distinctive house, right? So maybe it would be a problem. But ultimately to be a complete search, you should separate these designs and search them each on their own. Again, if searching designs separately yields too many results, you can always search within coordinated classes. Again, I did class 9 here, and you know why. This barely scratches the surface of searching, but I hope it was helpful.
It was. And then again, for anybody who's not sure or hasn't checked out the Design Search Code Manual, that's accessible immediately from the very homepage of TESS in the row that says free form. There's a link to it. I strongly recommend it. They have a design code for everything. It's phenomenal. One question on designs that less kind of how do you construct a search, but more how do you think about it? For designs that are abstract, it's not as clear as an elephant with a house or a donkey with a soccer ball. How do examiners go about breaking that down and deciding I'm going to search for, I'm thinking of these really modern designs that are very in vogue right now, that are just kind of parts of shapes and whatnot. How do you go about breaking it down into its component parts and determining what to search for?
Yeah, it's really tricky. There are lots of different design codes for incomplete circles, geometric shapes, quadrilaterals. It does take some time to figure out, and sometimes this is where talking to other examiners helps. Like something I might see, another examiner might see it all, or vice versa. So sometimes I'm like, do you see the number 8 here? And they're like, no, not at all. But you have to search the number 8 just in case, but maybe it's a swirl design that's not a complete 8. So it does get tricky, and it takes sometimes, some working together to make sure you're seeing what other people could see, because the mind plays tricks on you, and you're just really looking in that Design Code Search Manual for any kind of shapes, and you're combining. Sometimes if it's an incomplete circle, you're gonna usually search that in conjunction with maybe it also has a word in it. So you're searching, searching incomplete circles by themselves. That you just can't do it. There's just too many of them. So, it takes some kind of common sense and teamwork when you have really interesting ones where you're just trying to figure out what is it.
And how much does, you gave the example of do I see an 8? So I'm thinking about an infinity symbol versus 8 as an example. How much does what an applicant puts in the mark description impact the way you interpret a more abstract design mark?
I would say it does impact. It gives the examiner something to go off of, so it's helpful to have a detailed description. But examiners know that it's also how the owner wants you to perceive their mark, and it might not necessarily be perceived by the public that way. So
you're wise to our tricks.
Yeah, you can say it's a vertical infinity symbol all you want, but we're also going to search the number 8, right? So we're also going to search what we see.
Great. And with that, we just hit the hour right on the nose. I'm going to look through some of these questions and see if we can get some answers for everybody. Courtney, someone asks if there's any guidance from the USPTO as to which classes are considered coordinated.
That is available that should be available on the PTO website as far as coordinated classes, if you do some digging.
Okay, great.
Yeah, that should be available.
Real quick. All right. Wait. Before we go on to the next question, one more time. The CLE code is LHB5U. LHB5U. And on that note, it's all you.
Thank you, Bree. We have a question asking about, kind of going to figure out how to make this broader. So the questioner is asking if you receive an informal email from your examiner after filing a response to a descriptiveness refusal. And in the email, the examiner says, you should just think about putting this onto the supplemental register. Should we read into that as or else, or how should that be interpreted is the questioner's question.
If they're suggesting the supplemental register, then they probably mean that they've researched the mark and they really don't think you can make arguments that could get past it. But feel free. I mean, sometimes examiners don't see it the right way the first time. So, I mean, just because they suggest it doesn't mean you're doomed. But yeah, you can know that if they're suggesting it, they probably think it's because they're not sure it can go forward any other way.
Okay. Another question we have is somebody says, I've heard that in office action 2D responses, examiners are now looking at evidence of the marketplace for coexistence. They're not just relying on evidence of coexistence on the register. Given that you haven't been in the PTO for a little while, but as recently as you left, was that something you were seeing?
It's never just been the register. I guess I'm confused by the question. We've always had to find real world evidence. That's what examiners have to do. They can't just rely, just because there's a third party registration that says these goods are offered by the same source, you have to find real world evidence. And that's always been the way.
Great. Let's see this question for a moment. Oh, somebody's asking where they can find the resource of updated TTAB decisions. Are you guys looking at the reading room, or is there some other resource that you guys are working with?
Oh, this is internal. Yeah, it's not going to be accessible. It's internal.
As someone who's definitely not part of the PTO, I personally will sing the praises of the TTAB reading room, which recently got a great makeover and has become a much more useful resource, in my humble opinion.
Absolutely.
We have a question about how do examiners feel about longer office action responses that cite the TMEP and court cases? I actually think this is a great question. So, I mean, I'm sure we've all seen a variety in lengths of office action responses, both in terms of what we've filed, what we come across as we do our day-to-day work. Do examiners, are they pleased to have such evidence and length of, 10, 12 pages with thorough citations, or would they prefer all responses be only a couple pages?
I don't think there's any hard and fast, rule one way or the other. I think that examiners appreciate well thought out responses that have the citations. I think that can only help the case of the applicant.
Great. Well, that makes me feel a little more justified in my practice. Thank you.
Exactly.
We are getting follow-up questions about finding out where the USPTO posts the coordinated classes information. So I think I don't want to put you on the spot, Courtney.
Yeah.
So maybe that'll be the kind of thing we can track down after the presentation is over and ask Alt Legal to make available once we've located it.
Right.
So thanks everyone for your patience on that. Let's see. I will admit I'm trying to shield Courtney a little from questions that are just, why is my application or my client's application not proceeding? You're welcome. There's also so many coming in at the same time that I'm having trouble going through them. So Courtney, if you see one that jumps out at you, feel free to answer it.
Okay.
A lot of them do seem to be related to the question of coordinated classes in various ways, though. I will say one thing, while we locate that resource, one thing that many practitioners have recommended over the years is the TTAB blog will often issue cases and write-ups on cases that look at really interesting relatedness of goods questions. And the revised TTAB reading room now lets you search for cases based on the products and services and the classes at issue in those cases. So if you know what you're facing because of the particular office action you got, you can try to find TTAB cases in the reading room specifically by searching for cases that address the same categories of products across the marks at issue. Oh, here's a great question. The observation came up yesterday in a seminar on what seems to be a recent increase in failure to function rejections. Is that something that you observed when you were at the PTO? And do you have any thoughts on how outside attorneys can address that kind of rejection?
Yes, so failure to function refusals were definitely on the rise in my last few years there. I can't say as to why, how these things come about, but yes, the USPTO was cracking more down on failure to function refusals. So the question is, how can, practitioners deal with this? Really, failure to function refusals are really fact specific. You're just looking at how is the mark displayed on the specimen. So it's just really making sure that the mark you're dealing with is showing proper trademark usage. If it's a common phrase, it's not going to work. I'm not sure there's any specific advice I can give because it is so fact specific, but just make sure that that the trademark is showing proper absolute trademark usage.
We're getting some great question about trade dress applications and generally when you suspect as applicant's counsel that you might need to make a 2F claim. As an examiner or as a former examiner, would you recommend just front loading that at the front if you have reason to suspect it'll be requested? Partitioning it, keeping some evidence in case an office action arrives despite what you've presented, or just not even making any claims until an office action issues?
You mean whether or not to put the Section 2F claim right in the initial? Yeah, I mean, it's kind of like, do you offer the disclaimer up? Like all these, it's right. Up to how you want to handle it. But you could, but a lot of people, I'm sure, want to see if it's even necessary. So, it's really up to the actual practitioner.
That makes sense as a question of what makes sense for you, for the client. What are they looking for out of the process?
As an examiner, I always wondered why everyone didn't just put disclaimers in the applications. I mean, I can see what the argument against that now, but it's like, come on, this is generic. What's going on? So It's just up to your practice style.
That makes sense. I'm not seeing any more new questions come into our chat. So I think we have hopefully covered what everyone wants to request or ask about.
A little shout out to Ed. I was in law office 108.
Oh, that's great. Ed, let us know if you two cross paths without knowing it based on your law offices. With that, Courtney, thank you immensely for being willing to share so much about your knowledge and your experiences. I hope everyone found it as valuable as I did. Oh, wait, one more question has come in. Can you speak a little bit to any tips for what you're looking for in responses for refusals related to the PTO's enhanced specimen requirements?
Well, I think you probably know the ones regarding websites. You need to have the date and time and all that fun stuff. As far as, a lot of the specimen requirements you might know are from, there was a lot of Chinese applications that were completely fraudulent. So this is why they really had to crack down. So, I mean, I don't think that's a huge issue with, United States attorneys producing these marks. They're just literally pasting them on famous brands. So, I mean, I would say don't do that, but I don't think you're doing it already. So, basically keep doing what you're doing and make sure you're meeting the website requirements, the new website requirements. Yeah.
We also have a question that came in about foreign word translations, also known as many an attorney's headache. Do you have any insights into how the PTO makes those decisions in terms, how examiners make those decisions in terms of when to issue a refusal based on a translation, when they determine how something is considered a common language, et cetera?
Well, I mean, I guess if the question is, if you ever been asked to translate something you don't think you need to, I mean, if it's in the, regular dictionary and it also has a foreign meaning, you're not going to have to put a translation statement in there if you're wondering how that worked. As far as translations, if it comes up in a normal translation dictionary, you're probably going to be required to put it in there. Sometimes there's multiple meanings, so you might have more than one, and that's okay too. I'm not sure if I hit on everything that was asked.
Okay. I know that we could all listen to this forever. That's sort of why we do what we do. I will say, if you want to connect with Courtney Umbrella, make sure to send her a message. I don't know what her availability is. I don't want to speak to that. But, do that. But it is time for us to move on to our next activity, which will be your choice of virtual taboo or virtual charades. That's going to start in about 3 minutes. Again, these will be outside of Brella, but you'll find the links for those in the different sessions. You'll pick whichever game you want to play and click on that link to go to Zoom. And you'll join from there. All right, thank you so very much, Dorna and Courtney. This was wonderful and fantastic and amazing. And we all learned a ton from both the questions and the answers. So thank you very much. And thank you to everybody who joined us. I will see you at charades or taboo in just a few minutes. Thank you.
Thank you.
Bye.